All right. I am Jennifer Deland, and welcome to the a presentation of the Massachusetts Bar Association 2022 Elder Law Program. It's called The Power of Trusts. I am Jennifer A. Deland, Esquire. My office is in Holliston. And I think I will be talking probably for about 40 minutes with this little nifty little PowerPoint here. Can everybody see the screen? Everybody all comfy? You should have materials. If you open up, you'll see that you have an agenda. I'd like you to take that out, and you have a pen, which is my present to you, and you can make notes on your agenda if you would like. I'd ask you to write down any questions that you have. There will be a question and answer situation at the end. If you have, if you feel that I'm not being clear and you need to stop me at any time to ask a question, go ahead. My trustee assistant here is David Wormley, and he is the gentleman in the striped shirt. He is going to be available to help anybody who needs help during the presentation. All right, are we all ready to go? Okay, so just a quick overview of our agenda. We're going to talk about what a trust is. We're going to talk about single ownership, co-ownership, powers of attorney and wills, and again about trust ownership, because trust, the way to understand trusts is to put it in the context of all these other different things that people can use. Okay, there will be questions and answers at the end. Okay, a trust is a way of owning things. It is a very helpful part of estate planning, often overlooked, and it is something that I'm very passionate about. I think trusts are very important and very useful. Okay, so what is owning something? It is controlling the ability to buy, sell, rent, give away. When you start out with whatever planning that you're doing, the power is in your hands. You own things and bank accounts, property. You may own it with somebody, but this is basically where you start. If you don't do anything, if you just keep things in your hands, what could go wrong? You're alive but unable to act. No one can act for you, including your spouse, if you don't have things set up properly. A judge has to appoint a guardian, and I just had to go through that with a client. They had come into me with nothing in place, and she was already past the point where she could make any decisions or sign anything, and we had to go guardianship, and it was a pain in the neck. Okay. If you pass on without anything in place, there are ways. I mean, your family is not completely helpless, but they do need to get a judge to appoint somebody. And that process of getting a judge involved is complicated and not at all something that you can do on your own. So if you trust another person, why not co-own with them? This is a thing that people often bring up. There are a few reasons why you don't want to co-own with somebody. Liability, conflict, and taxes. If two people own property together, the creditors of one can reach the property of the other. And maybe you can show that the other person doesn't actually own your property, but you would have to show that, and sometimes it's not obvious. And we're going to go into more reasons why co-owning is a possible problem. So suppose you co-own an account, and then one of you dies, and then you add somebody, maybe a child, to your account, and then the original account owner, last of the original account owners, dies. And now you have a child owns the account, and then other children are wondering what happened, okay? Because there's not a process in place. A trust would allow a process to be in place so that the other beneficiaries, if there are other beneficiaries, have a claim. If there are not other beneficiaries and that last beneficiary dies, there's always somebody else who can take over. But the trust will avoid this kind of things being in limbo, and can often avoid family conflict, which can be kind of unpleasant. Okay, here's another case. Bob and Sue own a house. Well, Sue passes. Bob doesn't do anything. He's the gentleman with his arms folded. He passes. He's got 3 kids. Okay, they all own the house. Okay, it rains. Story that my grandmother used to tell. I don't know how true it is, but there was an empty lot, and she said, "Well, don't go in there. There's a hole in the ground." And I said, "Why is there a hole in the ground?" And she said, "Well, there used to be a house, and it was owned by 5 brothers, and they could not agree who was going to pay to fix the roof. And the result was the roof leaked, the floor rotted out, and everything fell into the cellar." If you have a trustee, the trustee has power to actually either say, "I'm going to sell it as is," if people don't pony up, or if the trustee can raise the money themselves, they can put money in and then be sure that they'll get it out, because they have the power to actually mortgage the property so that they can claim what they put in on top when the property is eventually sold. This is a very important thing. Now, what about spouses co-owning? If you have somebody who is and they're married, and Massachusetts taxes estates over $1 million, and everybody says, "I don't have $1 million." Well, you may be really far from $1 million, or you may not. Taxable estate includes retirement plans, life insurance, and the market value of real estate. Anybody notice what's been going on with real estate lately? Okay, so this can be actually a trap. You can leave a situation where between the 2 of you, the widower winds up with $1 million estate, and that adds the process of actually dealing with estate taxes. The actual tax in Massachusetts to pay may not be that high, but the whole process of filing a return is incredibly, stupidly complex. So spouses should have separate trusts. It makes settlement easier, it avoids the estate tax trap, and another thing that people say is, "Well, I just want to give my property to my child." We're going to talk about the kind of trust that you can use in place of this kind of gifting. The capital gains is the sale price minus the purchase price. The only problem is if you give somebody property, they take your original purchase price. Okay? If they inherit it from you, and there's been talk of eliminating this loophole, but it's not it. We're not even close to that happening. If they inherit it from you, the purchase price is the market price. And yes, a trust can create an inheritance. People say, "Well, I have a will. Why isn't that enough?" You should know that a will does nothing unless it is presented to court in a probate process. It requires probate, which usually requires a lawyer, and it's our job. We have to get paid, and it requires filing fees. These are usually only a few $100s. You have to file an inventory of what is actually in the estate. You have to give notice to legal heirs. So if you're trying to if the will benefits somebody who is not like a child, the children have to have an opportunity to object. And you have to put a notice in the newspaper. And the probate assets are subject to the decedent's liabilities. The person who died, their liabilities all have to be settled somehow or other when they die. It's kind of, being dead is kind of like being bankrupt, or vice versa. But here's the kicker. Probate is where the Medicaid lien is enforced, and we're going to talk about the Medicaid lien in just a minute and how it arises and how it is a problem. So what's the solution? You need to share your power. It doesn't necessarily reduce your power to share it, and it can help your people to know what to do. there are two things that you can do. You can do a power of attorney or a trust. The limits of a power of attorney, a third party like a bank, when they see a power of attorney, this is the first time they've seen it. And by that time, you are already non-functional. And your person who's walking in with a power of attorney, a bank or broker may say, well, prove to me that this is actually a good power, that this, they may say, well, I want the person who gave you this power of attorney to sign, and you'd be like, but if they could sign, I wouldn't be standing here. What is the problem? Okay. The other problem with the power of attorney is that it goes out when you die, which means that anything that a person was using the power of attorney for drops into your probate estate. And remember, that means going through the court, all the rigmarole that's involved in that. And so that's kind of, I'm not saying power of attorney is bad. It's a lot better than having nothing. It can give you power to handle a number of things which actually cannot be handled by trusts. But the power of the trust, the power to protect your property, when the bank or broker sees the trust, it's not the first time they've seen it because the property is already in, or the account is already in the trust. Okay? And the type of trust we're going to talk about mainly here is a trust that is effectively sharing your power, not giving it up. And this is called a life or living trust. You and your spouse can be trustees. So if you're used to having both of you on any account, both of you can still be on the account. Or you can name a trustee. And my favorite story about this is the little old lady who wouldn't get out of bed. She sent her son to one of my seminars. And basically it became clear that she calls all the shots, but she can't go to the bank. She can't go to the lawyer. She can't do anything because she can't get out of bed. And she was really old and really kind of frail and fragile. What it wound up with me was literally going to her and sitting on her bed and walking her through this process. But she needed to appoint a trustee. The trustee is the person who does the work involved in owning something, who actually does the stuff, figures the stuff out, signs the things. And if you can't do that because you're all confused or something, or because you can't get out of bed, you need a trustee. Okay? The nature of a life trust is that you're the only beneficiary. Now, your spouse has their own trust, and of course anything that benefits you benefits your spouse. So often we'll have the house in one trust and other things in another, and that's fine. But the trustee is the person with the power, who owns and controls the trust assets. The beneficiary is the person for whose benefit the trustee acts. And this is why a life trust is like, it's like that candle that we showed in the picture that lights another candle. It doesn't reduce your power. I often have people who are kind of resistant to putting accounts in a trust because they feel as if they'll lose control over it. With a life trust, that is absolutely not the case. When you put your account into your trust, you retain control over it if you are your own trustee, which you absolutely can be. But you have the added assurance that if somebody else needs to take over, if you become non-functional or if you die, you have a backup trustee who can take over. And you remain the beneficiary as long as you're alive. Okay? Your life trust beneficiary is you. Okay? After you die, your life trust benefits who you say it should. Okay, so this could be children, other people, charities, you choose. Okay, and so if you're working with me, one of the things that I'll be asking you to do is figure out, okay, who would you benefit? And if that person isn't there, who would you benefit? Okay. Now you also need a will if you're having a proper plan that has a life trust in it, because sometimes there are things that you might have an inheritance. Somebody dies just before you do, and suddenly there's property in your estate that just isn't in the trust. And so we have a pour-over will that simply says, take anything that's in my probate estate and put it in my trust. Okay. The trustee can own your bank account. Other property, you can be your own trustee or name someone else. Your trust continues to operate after you die. Unlike the power of attorney, it goes on. Now, that doesn't mean that nothing changes. When you die, your trust, which had been using your own social security number, now needs to get a tax ID number of its own, which is the same thing that would happen if you died without a trust or without anything. You leave an estate and a tax ID number is created for that estate. And it's the same tax ID number. So if you have some things in your trust and some things out, one tax ID number is fine. Okay, and it is you. It has your power. It benefits you while you live. It also has your liabilities. And this is actually important. You owe money. Your life trustee has to pay it. Now, they may not have to pay it all at once. If you're still alive, they don't have to pay your credit card bills off or anything like that. But when you die, your bills have to be settled somehow. I mean, if they can't be, then some sort of arrangement has to be reached. And that's your trustee's job. Your trustee's liabilities, this is an important part. So if you want to have somebody else on your account, by using a trust, you avoid the problem of joint ownership where it becomes partly their property. It's never their property. They just have a job of being trustee for this asset. But your liabilities have to affect it. And as I'll explain in a little while, you absolutely have to have something that your liabilities affect. Okay, now we're going to talk about some awful liabilities here. So a lot of things, you have health insurance, where many of us are learning now that health insurance doesn't cover anything, but a big loophole in all health insurance, the biggest, fanciest Cadillac plan in the world, does not cover long-term care. Long-term care is when you need to be looked after for more than 3 months. You may be at home or you may be in a nursing home, but this is long-term care is a thing that basically Medicare does not cover. So your options for paying for long-term care are you either have enough income, in which case congratulations, okay? You have assets saved up that you can then spend. Okay, again, congratulations, sort of, although you may not want to spend them, you may not have much choice. Some people have long-term care insurance. It's hard to get and it's expensive. Highly encouraged if you can get it. It has many benefits. The last resort for paying for long-term care is Medicaid. Medicaid is not Medicare. Medicare is the health insurance that most of us probably have. I just got signed on to Medicare. I'm so pleased with myself. But Medicaid is another thing. It's needs-based. It's not just that you get it because you're a certain age. It's you need long-term care and you have not enough income. And they want you to expense your assets. And this is where the Medicaid lien comes in. Because they will let you keep your house on the theory that after you die and your spouse dies, the house is going to be sold and that money is going to be used to repay Medicaid. Okay. Medicaid has a lien on the house for the cost of your care. Unless you have long-term care insurance. If you have long-term care insurance, that will protect your house from the lien. Or your house is in an irrevocable trust. An irrevocable trust is different from the life trust that we were talking about. Very different. But an irrevocable trust allows you to avoid the Medicaid lien. The type of irrevocable trust that I do for people mostly is a irrevocable income trust. You can live in the house. That's the income part. You can change the trustees. And I haven't really highlighted it here, but you can also have an arrangement whereby you can if the house has been sold, for instance, and there is money, you can give the money to other people, but not to you and not to your own creditors. You cannot spend the value. It's hard to get this property refinanced. Property that is in a living trust can often be refinanced, but property in a irrevocable trust, I have found that for some reason banks are reluctant. Okay, now you may have heard of the 5-year look back. Anybody heard of the 5-year look back? Okay. What this means is that although you have protection against all your liabilities once you put the property in the irrevocable trust, if you apply for Medicaid, if you need long-term care and you apply for Medicaid, Medicaid will want to add the trust property back in determining your assets. Okay? And there are things that can be done depending on the situation. You can, for instance, maybe rent the property and tell Medicaid that it's producing income and therefore it should be disregarded. There are a variety of things that you can do. And depending on how the trust is constructed, there may be other things. So this 5-year look back, it's not that it doesn't do, the irrevocable trust doesn't work until 5 years. It's just that it works better after the 5 years has passed with regard to Medicaid itself. And that's a reason just to think about doing it sooner rather than later. And I apologize. I'm going to be coughing. I thought I would take a cough drop, and then I realized that I will probably choke. So it's not impossible. So don't feel like, now I have had people, if somebody comes into me and they're obviously immediately needing long-term care, I'm going to be really suspicious at the idea of doing an irrevocable. I would really want to look over what this whole situation is before I propose that they do that, because it can create stickiness. And people will need legal help. So, if somebody came to me and they wanted to do an irrevocable, I'd really be wanting to look, in detail into what their whole situation is and what their plan was in terms of getting the care they need. So sometimes people say, well, the irrevocable trust is the way to go, clearly, because it's protective. Not so fast, okay? If you put your money in an irrevocable trust, where it's not available to pay your creditors, that's a fraud on creditors. You cannot do that, okay? And besides, you should keep some of your money in a place where you can spend it, As it's kind of, and that's why an irrevocable trust should always be an extra in addition to the life or revocable trust. Okay. So what other types of trusts are there? There are gift trusts. There are special needs trusts. Sometimes somebody needs, you have somebody who's dependent on the type of Medicaid that provides for people who are not able to work at all and never have, and so you might have somebody who is really lifetime incapacitated, and you want to provide for them without interfering with any program that they may be on. That's your special needs trust. You may want to make a gift and not retain any strings on it at all, or you may want to make a gift and be the trustee. Actually, this is actually funny. I have a gentleman who's made trusts for all his numerous grandchildren, and at first he had them set up as Uniform Gifts to Minors Act, Uniform Transfers to Minors Act, UTMA accounts. Well, it turns out if you have accounts in an UTMA account and you are the guardian on the UTMA account, that's included in your estate for tax purposes. And he did have a Massachusetts estate tax problem. He had enough money. And so we changed them to gift trusts because it just makes no sense to have it not to be able to set it outside his estate, since he did want to make a gift to the children. And he wanted to be the trustee. Then there are special fancy trusts, and if you have one of these, you have something that you don't know what it's for, somebody else set it up, it's got you all confused, you should see a lawyer and make sure that you understand what's going on. Common kind of these that used to be very popular was irrevocable life insurance trusts. For some reasons having to do with the way the tax laws have changed, they're no longer so popular, but if you have one, you want to make sure that it works, okay? And there are other special trusts for special circumstances. Okay, how many trusts? Each person should have their own life trust. Okay, spouses can be co-trustees on each other's life trust. If one spouse dies, the surviving spouse may keep the other one's trust going. And there may be good tax reasons for doing this, and so one person may have 2 or 3 trusts. You can have additional irrevocable income trusts. If you have more than one property, you may want to have more than one trust. I think my maybe my kind of record so far is a couple who has 4 altogether. They each have an irrevocable trust, and then they have their own life trusts. Okay, so I feel as if that wasn't very long. Yeah, it was only about 15 minutes, and that's fine because I don't aim to be tedious. I will let you know that if you want to know more about that, you can get a consultation with me. And if you mention this meeting, we will waive the consultation fee, which is usually $400. It's applicable in any case to what you actually agree to do, if you want to agree to do something. But now what I'd like you to do is, as we move to questions, I would also like you to look for the blue should be in the bag here, evaluation form. And I would love to have you evaluate me, and I would love to have you, where it says complimentary consultation, I'd like you to check off yes. And if you give me your contact information at the top, I can then, it would then be permissible for me to reach out to you. Now, if you don't want to do that, that's perfectly fine. If you don't want to give your contact information, that's fine too. But I would love comments, and I would also love to answer any questions. Gentleman in the back.
You know, based on your initial consultation fee of $400, what is the average to set up a will and a trust?
In the vicinity of $3,000. Varies from, it may vary depending on the size of your estate and the amount, the sort of complexity of your family situation. I may ask for a little more. It's a project. I'm not saying it's not a project. One of the reasons that I want to tell people about this is, not necessarily that they would come to me, but if you're thinking about this stuff, you should know what you're thinking about.
If it's $3,000 and you have more questions and you have to talk to you, say if you call.
Okay, so to clarify, this consultation fee, this consultation meeting, which is usually $400, it is free if you mention that you came to this meeting. And yes, you will give me a chance to actually, consult with you. The more information you give me, the more I can tell you about stuff. Okay, if you want me to do work, there's going to be money involved. But if you just have additional questions that relate more to your individual situation, I will always want to look at how things are set up now and know a little bit more about you before I start giving you personalized advice, but I can certainly do that. I love my people who come from one of these talks that I give.
Yes, but I mean, it was $3,000 you stated to go in.
To actually set the thing up, yeah.
Yes, okay. Now, if you had to have consultations after that to talk to you.
Oh, for heaven's sakes, that we do
Per
all the
hour.
consultations. When one part of what I cut out was of this talk today was the long explanation of how I do things. It's meeting after meeting. You have lots of, part of the reason that I'd have to charge an amount is because I want to make sure that people are not prevented from coming to additional meetings by that concern. I do not charge by the hour, and I always spend plenty of time with people. I always feel that I need to get started. I need to work with people on a kind of gradual basis before I really get to understand what the situation really is. And if I try to speed up too fast, that's when mistakes happen. So I love to have additional consultations. However, if you just get a free meeting, that's just one meeting. If you wanted to have more meetings and go into more detail, then maybe we would ask for a consultation fee. But we would talk about that. Okay, here?
So, I have a question about this irrevocable trust thing.
Yes.
Okay, so suppose I put my house, just my house in that, and then in a couple of years, my house is stairs and I can't go up and down the stairs anymore and I want to sell it. Can you sell it?
Absolutely. And I actually had a lady who decided she couldn't handle her house at all, and she sold it. And somebody else, her uncle, I think, had been her trustee. I recommend that you name somebody else as trustee on your irrevocable trust. But he didn't really want to get involved, so she named herself as trustee, sold the house, invested the money, and then named somebody else again as trustee because she was not really able to handle it anymore. And that money is still paying out to her. It's invested in bonds, and it makes her a certain amount of extra income every month. And it has been a very good thing. You can also, I've also had people who sell a house. I've gotten a couple right now who's selling one house, buying another. Yes, you can do that.
And can you, suppose I run out of my money, the way things are going up and up, and I have no more money, then can I get money out of the irrevocable trust?
Well, we would talk about that. It depends how you want to set it up. It's possible to set it up so that not you, but maybe people in your family might be able to have distributions made. So yeah, there are ways. I always want to make sure that I'm not putting somebody in a position where they're so totally locked in that it can be a worse thing that they did this. I don't want to do that. So that's why I always want to make sure. Again, it is an add-on. I would be working with somebody on the setting up the life trust before we would get to the irrevocable.
The issue of probate, what's the threshold before it has to go in through probate?
Anything that you own, that you die owning, and nobody else has a claim to, only the court can determine that. If all you leave is one car and a tiny bank account, there is a slightly less messy process of probate, but it's still probate. Gentleman over here?
Yeah. Once you have a trust, does still have to go through probate, or it bypasses the probate procedure?
Okay, what bypasses the probate procedure? A trust bypasses the probate procedure. Retirement plans, if they have their beneficiaries, that passes the probate procedure. Life insurance, if it has beneficiaries, does not go through probate. You can have payable on death on your accounts. There are DIY approaches that you can use. But there is a right way and a wrong way to avoid probate. I have seen people try to avoid probate and make a complete pig's ear. You do not want to do that. If you are going to set up an arrangement where your property is going to bypass probate, you don't want to use, well, for one thing, you want to set it up yourself while you're conscious. And you want to make sure that everybody understands how it's set up, because now you've got if each asset has its own designation on it, then somebody at some point has to, figure out how the whole situation is. That's why I think that the trust arrangement is simpler, especially for the people actually doing the settling. It is simpler than the process of trying to figure out what accounts you have and what beneficiaries you put on them. Gentleman back here.
What things don't go in an irrevocable trust?
What things don't go in an irrevocable trust? Things that you would want to spend, okay? Active accounts that you take money out of and put money in do not go in an irrevocable trust. That's the fraud on creditors that I was talking about. No, you have to have at least one active bank account that is not in your irrevocable trust. You can have an irrevocable trust that it can own stocks and bonds, it can own real estate, it can own a life insurance policy, but it should not own anything that is active, that you're actually using to pay creditors. So that's why I always say, no, it's got to be an add-on. You cannot just have that. Okay, somebody else?
Thank you.
In a trust, one has to get to the permission of the co-owner to be exercising any funds out of it.
Okay, if you have a co-owner already on your account.
Okay.
Yeah, okay. Do you need to get the permission of the co-owner? Yes, if you already co-own, that person should come to you to plan if you're going to do further planning with that property, because they own it.
Only if that account is in the trust.
No, it isn't. If you co-own with somebody, okay, you both have control over the property. So if it's a bank account, either one of you can take all the money out, but probably both of you have to act together to close it. And in terms of real estate, yeah, if you co-own, basically, if you want to sell, both of you have to sell. Otherwise, it gets really messy. This is why I don't recommend against co-owning. But if you started with co-owning, and you come to me with co-owned assets, we will work it out. A common case is somebody has named their child as a co-owner, and then the child moves to California. And, well, next time they come home, can we go to the bank and get this fixed? Because it's kind of not working. So that's the kind of thing that I really need to address on an individual basis. Okay. So if we got any, this lady.
And if you already have the will and it's not in a trust, and you have it in one of your children's name, I was told it's a conflict of interest if you put it in, I have 2 children, in both of their names to pick one, not the way.
Okay, so the process of picking who is a process of planning that you would go through with your lawyer. And the lawyer would explain that, yes, you can have just one child, because that child, if they are the trustee and both children are beneficiaries, they then have a legal duty to the other child. So it does not create a conflict of interest. The conflict of interest is when you give all the money to one child and think that they are going to give money to their sibling. It may not happen. And that is, it's not actually a conflict of interest, it's simply poor planning. And it does happen that people do that. They'll say, well, I trust this child, I want this child to handle everything. Yeah, but give them some direction, some guidance, so that people know what is actually going on. Okay. Gentleman way in the back.
What would you charge for rewriting a simple will?
What would I charge for rewriting a simple will? Okay, so once again, if you mention this, you can come and have a meeting with me, and there's no charge. If you want to have more meetings, it's going to be $400. If you want me to do estate planning for you, yeah, it's going to be a fee. And we would have to arrive at an agreement about how much that is. If you have a will existing and you have this, on the basis of that, you have some ideas about how you want to change things, that does help, but it doesn't necessarily make my job that much easier. It helps because it's additional information. I did have somebody come in with a will that he absolutely wanted to be effective, and he was like, I'm dying tomorrow. And so it was a really not a very good document, but I kind of recast it so that it would be sort of a will, and had him sign it, and then I said, and now we're going to do estate planning, right? And we actually did do a trust and a pour-over will and the whole thing, but he was just anxious. Okay, so, I'm willing to work with people. I love to see that you've been thinking about your stuff, and if you want to bring me drafts that you have worked on before, that's wonderful, that's helpful. I don't mean to say that it isn't. But when I create documents for you, they will be, they may incorporate some parts of what you have already done, but it's not the same, it's not like rewriting. It's like incorporating what you have done, and it's not the easiest part, but it's not that bad either. I love to have people have thought about stuff, but I also love them when they come and they just look at me kind of blinking-eyed and say, I don't know where to start. That's wonderful too. Either way, we get to a point where we are on a page together and we are actually putting together a project that works. So I wanted to stay out of kind of trying to sell myself here, and so I cut out all of that stuff from my PowerPoint, but it turns out actually you want to know that stuff, and that's okay. I'm glad to tell you, because I do work in a different way than other people do, it's many people find it a good way to work. So I'm looking forward to hearing from some of you. We got anybody else has got any questions? More questions?
Basically,
Yeah.
if I pay you $3,000 for a trust and I die within 5 years, they're still going to take all my money. Or if I go into a long-term care situation, they're still going to get the money, right?
Not necessarily.
It's the 5-year look back.
That's right. So you might not be able to apply for Mass Health, but suppose you just die. You don't actually go into a healthcare facility. You just die at home. Well, the benefit of the irrevocable trust is that the people who are selling your house don't have to worry about any of your debts. They can just go ahead and sell it and split the money, and then the debts are only against what was in the life trust, which may turn out to have nothing in it, or very little, and that's okay. I'm not, I insist that people don't commit a fraud on creditors. That doesn't mean that I'm going to make it, I'm really interested in making it real easy for creditors, especially health insurance creditors, to get paid. I really think that what you want to do is you want to have a setup that gives your people the power and the authority to make these decisions, and not to have to turn to the court, especially because at the court, that's when Mass Health comes in. If you had been in a nursing home and say your people had applied, they had said, well, they're renting your house, so it's property for self-support, so it's fine. And then Mass Health turns around and says, we're going to lien this. Well, no, you're not. No, you're not, because it was in an irrevocable trust, and there isn't a claim you can raise. So it is worthwhile to set things up, but yeah, it costs money, and you do have to think about, well, is it worth it? It costs money and effort and thought and putting things together. But if it's worth it to you, it can be worth it. It can make a difference to you and your family. And the whole process actually can be more interesting than you might think. Okay.
How do you feel, and I don't know if you can get into the subjects, about these new places they have for 55 and up, like the Willows in Medway, or a new pond, I think, in Walpole? You pay so much a month, like I think Medway is $6,000 a month for like a one-bedroom apartment. And I just learned that the little cottages they have in the high 800,000. I don't know if you lease it,
Okay,
purchase it.
I don't have any particular thoughts about these things. If you're looking into one and you want me to help you look through the contract, I mean, that's a thing that I could do. And I do sometimes do things like that for people. You know, again, if you're buying a service, you have to consider, is this what I want to buy? Is this going to be worthwhile? My mother was in one of these independent living places, and it was just fantastic for her. But, you know, they're not cheap, and there's a reason for that. So.
Yes, you have to be a millionaire.
This lady here, I don't think we heard from you.
Would you say that most people could benefit from having a trust?
Most people can benefit from having a trust. I do believe so. Many people say, well, I don't have enough money to make it worthwhile. But if you leave nothing in place when you die, your people are going to go to a lawyer, and the lawyer's going to say, I need like $10,000. And they're going to go, what? Whereas if you have a trust set up and it's just a little trust and you just have a few things in it, your people may be able to just go down to the bank and say, hey, I'm the trustee. I mean, I recommend consulting an attorney, but it's not the huge project that doing a probate case is. So yeah, I have done trusts for people with very little money, and it has been worthwhile. Among the other kinds of trusts that I didn't mention was the funeral trust. I sometimes do that for people who are applying for Medicaid to make sure that there's an amount set aside for the funeral. And there are just all kinds of things that one can do. You don't need to have, and when I have a Medicaid client, we use a revocable trust to keep the like $2,000 that they're allowed to have, because you want to have your trustee in charge of that. You want to have your trustee empowered, and you don't want to have to go through a whole big deal and then find out that your poor trustee has to pony up because closing it is such a big deal. It's just much simpler with the life trust. I really recommend them to everyone.
What is the difference between irrevocable and revocable trust?
What is the difference between an irrevocable and a revocable trust? Okay, the revocable trust is the life trust that I told you about.
Mm-hmm.
It is you control it, you can amend it, you can revoke it. That's why it's called revocable. And an irrevocable trust, you cannot amend, although it can have built into it some moving parts. It's stiffer, and it does not. It typically does not provide that it's going to pay for your. It's going to pay your bills. So that's why you need both, at the least. So. This is wonderful. If you have your evaluation sheets, David will collect them. And raise your hand if you have it. If you're,
So you would just call your office if you want to set up a...
Absolutely.
Okay.
Yeah, I will be the person that...
That's right. You can call my office.
Can you do it today?
These materials are for you to take home, and my number's on there.
No, because I got to...
Okay, so you can have it. Because clearly I need...
All right. So, I'm still here for questions. I just wanted to kind of move the evaluation sheets along, but if you're, so now how long have we been? Okay. Yeah, that's about our time. So, which is not to say that if you would like to ask any more questions, I'm not still here, but that's about what I had to say. Thank you.
Thank you very much.
Thank you very much.
Thank you.
You're a lovely audience.